If you want to take on property division and high asset divorces, you've come to the right place. All of the financial aspects of a divorce, everything from property division to alimony to child support, is impacted when there are complex financials. But of those three, property division is the one with the most moving parts. The first thing that you need to know is that generally in high asset cases, the property division issues fall into one of three categories. Whether a certain type of property should be included in the things that the court's dividing. Two, if so, how to value it. And three, how to divide it. I'm assuming for our purposes today that there is not a prenup in place. If there is, things tend to shake out a little differently. You're going to want to call us. But for our purposes today, let's assume that's not the case and proceed. Now let's talk about the issues that are involved in determining whether a certain type of property can be divided by a Connecticut divorce court. Many people are under the impression that there are types of assets that either can't or won't be divided in a divorce. Think inheritances, trust assets, trust income, stock options, deferred comp, ESOPs, RSUs, etc. You get the picture. Generally speaking, this is incorrect. Here's the background. Connecticut is what's called an all property division state. All property means that the courts have jurisdiction over all of the property owned by both spouses, regardless of who owns it, how it's owned, when or how it was acquired. So the concept that you might have heard of about marital property and separate property that exists under the state laws in other states really isn't in play in the Connecticut all property approach. Even given all of that, there are some times when a court does not consider certain assets to be property subject to division. Let's talk about that. So the things that are contingent on a future event that is outside of the control of the spouse, those may not be considered property subject to division. So let's do an example. Let's take a situation where one spouse is named the beneficiary of someone else's will. That person can change their will at any time in the future. Therefore, theoretically, that potential inheritance is considered an expectancy and something that wouldn't be property subject to division in the divorce. Now let's turn to the issues that tend to arise in financially complex divorces when we're trying to value the property. So I like to use an example here. Let's say prior to the divorce, a husband funded an irrevocable trust, which, among other things, owned a large home. Under the trust, the husband was a beneficiary, but he had no power to either revoke the trust or to invade the corpus. However, the trust allowed him to live in the home owned by the trust. So, what's the value of that trust for purposes of property division in the divorce? Well, that was an actual case. And in that case, the court determined that the trust's value wasn't the value of the house itself. It was the value of how much the house saved the husband in living expenses. Before we finish up, let's talk about how these assets might get divided. So Connecticut is an equitable distribution state. And the key thing you need to know about that is equitable does not mean equal, doesn't mean half. It means what the court considers fair. There is a series of factors that courts use to determine what is fair. But the key takeaway is the court has a lot of discretion over how each piece of property will be divided. In other words, if you and your spouse are able to work with your lawyers and reach agreements outside of court, you're going to have a lot of predictability and control over the outcomes that you get. You're also going to save a lot of time. Out-of-court resolutions can happen in all of the divorce types. They can happen in mediations, collaborative divorces. They can even happen in litigations. To learn more, reach out.